Welcome to This Explainer. I am super thrilled to have you here today because we're taking a really focused deep dive into a document that, well, fundamentally reshapes lives. Today, we're decoding the legal complexities of the divorce agreement, specifically honing in on the framework established in Mexico's federal district. So grab a coffee, get comfortable, and let's demystify this legal code together.
Now, right off the bat, here's a reality check that absolutely fascinated me. Did you know a judge can actually strike down clauses in your divorce agreement if they reproduce structural gender inequalities? It's completely true. And honestly, this immediately proves that this document isn't just a stack of dry paperwork waiting for a rubber stamp. It's a living, breathing legal framework with massive human rights implications. The courts are actively scrutinizing the balance of power here, which makes understanding the ins and outs of this topic incredibly vital.
So here's our roadmap for the analysis. First, we'll cover the divorce agreement itself. Second, the 7 essential requirements. Third, we'll explore what happens when there's an agreement versus a disagreement. And finally, we'll wrap up with jurisprudence and equity. Okay, Section 1, the divorce agreement. Basic concepts. Let's set the foundation. Think of a divorce agreement as essentially the ultimate legal rulebook for navigating the separation process. You see, when a spouse decides to unilaterally promote a divorce, they can't just walk into a courtroom and demand it. No way. They are legally required to attach a proposed agreement right there with their request. This document has to anticipate and regulate all the consequences of dissolving the marriage. It literally sets the baseline for the couple's entire post-marital reality. Moving right along to Section 2, 7 essential requirements, the anatomy of the agreement. Under Article 267 of the Civil Code, there's a really strict checklist you have to follow. And the first half is heavily focused on family-centric obligations. The law demands incredible specificity here. First off, you must clearly designate who gets custody of the children or incapacitated persons. But it goes way further than that. You have to establish the exact modalities for the non-custodial parents' visitation rights, and you actually have to legally respect the children's meal times, rest, and study hours. Plus, the agreement has to detail exactly how alimony, child support, will be paid. That means specifying the method, the place, the date of payment, and, this is a big one, providing a financial guarantee to ensure it actually gets paid. Then, we shift gears to the financial side of the checklist. The agreement has to legally dictate exactly what happens to the couple's physical and financial assets. You've got to clearly designate which spouse gets to use the marital home and all the household goods. You also need a totally comprehensive plan for how joint assets will be administered while the divorce is actually being processed. And finally, you have to present the method for liquidating the marital partnership entirely. This often means bringing in inventories, appraisals, and partition projects. Basically, you really have to show your math. Now, keep this specific number in your head, 50%. This represents one of the absolutely most vital protections tucked inside Article 267. So if a couple was married under a separation of property regime, the spouse who predominantly dedicated themselves to housework or the care of the children actually has a specific legal right. They can request compensation of up to 50% of the value of the assets acquired during the marriage. Now, the family judge will determine the exact final amount based on the special circumstances of the case, but this is huge because it formally recognizes domestic labor as a massive contribution to the household's wealth. That brings us to Section 3, agreement or disagreement, the 2 legal paths. So at this point, you hit a fork in the road with 2 distinct procedural paths. On the one hand, you have the most efficient route governed by Article 287. If both spouses completely agree on the terms of the proposed agreement and, it doesn't violate any laws, the judge simply approves it outright and issues the divorce decree. Smooth sailing. But on the other hand, we have Article 272b. If there are differences and the spouses just cannot agree on the proposed terms, the judge must immediately step in and summon both parties within 5 days to try and actively promote a consensus. Let's break down exactly how this builds procedurally when those differences pop up. First, the responding spouse formally answers the request. Second, that 5-day judicial summons occurs. Third, there's a real mediation attempt to try to bridge the gap. But step 4, well, that's where it gets really interesting. If mediation fails, the judge will actually still decree the divorce. So the marriage itself is dissolved right then and there. However, the rights of both parties regarding that disputed agreement are left open to be fought over in a separate incidental trial. So you're legally divorced, but the battle over custody, assets, and alimony, that's really just beginning. All right, let's move into our final segment, Section 4, jurisprudence and equity, the modern twist. Modern jurisprudence has drawn a very hard line in the sand regarding fairness.
Courts have explicitly ruled that any contractual clauses within a divorce agreement that foster a patriarchal system, meaning structural inequality between men and women, are strictly unconstitutional. As I touched on at the very beginning, a judge is not just a passive administrator ticking boxes. If they see an agreement that leverages historical gender imbalances to disadvantage a woman, they have the authority and really the duty to strike those clauses down. Equity completely supersedes a signed piece of paper.
And that logic builds perfectly into another absolutely fascinating legal precedent. A lot of people just assume that once an agreement is signed by mutual consent and elevated to a finalized court judgment, it can never, ever be touched. Well, actually, scratch that, it's totally false. Crucially, alimony, even when it's been set by absolute mutual consent, is not definitively permanent. If circumstances change drastically down the road, that alimony amount can be challenged, reviewed, and modified through an incidental procedure or even a completely autonomous trial. The law basically remains adaptable to ensure ongoing fairness.
Which brings us to our big concluding thought. If the ultimate goal of family law is to resolve conflict and protect the vulnerable, what does drafting a divorce agreement truly represent? Is it just a tedious administrative procedure to check off a list, or is it a genuine opportunity to construct an act of true equity? As we've seen today, this document carries immense legal, financial, and societal weight. Grasping its anatomy is really the first vital step to ensuring fairness and justice for everyone involved. Thank you so much for diving into this analysis with me, and I'll catch you in the next explainer.